Thank you so much, Professor Halmay, for the invitation to be here. When you wrote me with the topic, I started immediately to run with my mind on the 1,000 things we can say about this fantastic issue. I'm very happy that due to an unfortunate technical problems, whose fault is mine and only mine, I was the second speaker, because Marton did such an excellent presentation. He laid down with such a passion and precision most of the important issues that I can be a bit quicker on some of the more technical points and start right away with some messages, because I understand that many of you are national judges but also practitioners. Some of the key messages that are important for you to keep in mind in your day-to-day role. I will start with a small presentation on the role of the preliminary rulings itself, to move to the role of preliminary rulings in the protection of fundamental rights, concentrating in three functions that Marton has already masterfully presented: the control of national law, the control of EU law, but also the dynamic role in the shaping of EU law, national judges as co-creators of EU law. So what can be said about the role and function of the preliminary ruling procedure? What could be the metaphor that we could use? For me, it could be portrayed as the artery through which the blood of EU law, which is a new and innovative legal order, connects with the heart of the legal life of citizens. And this legal life happens not in Luxembourg, but in national courts and at the national administration. But let's concentrate in national courts as the heart of the preliminary ruling procedure and in general of EU law. So the essence and function of the preliminary rulings is connected with this role of national courts. There is an easy version to the role of the preliminary ruling procedure, which is, of course, Article 267 gives this procedure the function to use the Court of Justice to interpret EU law in a uniform way and to also check the validity of EU law. But this twofold official function carries with it a much more complex universe of interaction between EU and the national legal order. So in a nutshell, the preliminary rulings procedure is the key not only of the uniform interpretation, but of the development and effectiveness of EU law. And it is the pill that ensures the coexistence of these two legal orders. It is the way in which EU law happens, because it is the key for the sustainability and the self-adjustment of this ever-changing multi-level legal order. So it is today acknowledged that the procedure, this procedure, the preliminary rulings, is what has made EU law what it is today. The features that define EU law today as a legal order, primacy, direct effect, state liability, the very same features that have emancipated EU law from international law, all these principles have been developed as a response to questions put there by national courts. And not even last instance national courts, but lower courts. Van Gendel Laws comes from the Tarifkomissie, Costa contra Enel comes from the Giudice Conciliatore di Milano, or even Frankovic from the Pretura di Vicenza. So all these rulings, and in the discovery of all these principles, the preliminary ruling procedure was not just the vehicle to pose a question and to set this principle in the agenda. So it means that these principles were in the agenda of national courts more than of the national court itself, more than the EU court itself. But in the discovery of these important features, the preliminary ruling procedure was also an element of the reasoning. So in a nutshell, just to go to Van Gendel Laws, the argument could be that because the treaties have this type of procedure, EU law needs to be directly effective. So this is more than a procedure. It's an element of the system of creating the law. But now, leaving aside for a moment this historical perspective and fast forwarding 60 years after those seminal rulings, today, the preliminary rulings procedure continues to be the cornerstone that supports this paradigm of integration through law. The preliminary ruling has and continues to be the most important procedure in numerical terms. Just to be a little bit of a statistics person, the annual report of the court for last year shows that out of more than 800 new cases, more than 500 cases were preliminary references. And today, the days where it was hard to convince some jurisdiction to send questions to Luxembourg are gone. Now, all the member states, without exception, are sending questions to the Court of Justice. And the most curious thing is that, leaving aside, of course, the obvious leader, who is Germany, who sends almost 100 preliminary rulings a year, now Germany is followed not by Italy or the Netherlands or Austria, as it was the classic questioning states, but by Poland, followed by Bulgaria and Romania. This is telling us something quite powerful. Also, the content of the questions is not just tariff classifications, right? So the crucial role of this preliminary ruling procedure, together with the intensity of the workload that this procedure gives the Court of Justice, often leads us to say that the preliminary rulings procedure could be victim of its own success. Of course, the court has become overburdened due to the intensity to which national courts make use of this procedure. So this is also a problem because this makes the procedure longer due to the workload of the court. And the key for this procedure to work is that national courts can be able to have a reply quickly because the national proceedings are suspended, and this will, of course, affect the effective judicial protection of the parties. That is why the Court of Justice has struggled through decades to speed up this system, to rationalize it, to constantly modify its rules of procedure, even inserting a specific urgent preliminary ruling procedure in the area which most directly affects fundamental rights, which is the area of freedom, security, and justice. For all these cases related to asylum, borders, migration, but also family law, civil cooperation, criminal cooperation, national judges can explicitly request the urgent preliminary ruling procedure that makes the court as quickly as being able to adjudicate in 4 or 5 months on the basis of this exceptional procedure. But also on the basis of this need to be very productive and to give national courts a quick reply, the court has launched the last reform of the statute that has just started to be applicable in October 2024. As you might know, as national judges, if some of you come from administrative jurisdictions, the last reform means that for the first time in history, the Court of Justice is going to share its preliminary ruling jurisdiction with the General Court in 6 specific areas connected with indirect taxation, VAT, excise duties, the customs code, the tariff classification of goods, but also in cases concerning consumer law and compensation for assistance for passengers in this particular field, or in the field of environmental law, the specific field of the scheme of greenhouse emissions allowance trading. So what I'm bringing this up, this change, this fundamental change in the procedural structure of the preliminary ruling, because this new system of shared jurisdiction has met a lot of reticences. I'm not going to talk about all the problems that this has raised, but one of the reticence was of historical nature, is that this reform has broken the tradition that the preliminary rulings procedure was the jewel of the crown. It was monopolized by the Court of Justice, not shared with the General Court, because 2 elements: the need to ensure a sole uniform interpretation, but also the constitutional flavor of the preliminary ruling procedure. Not only because this procedure was created taking as an inspiration the procedures of constitutional questions in some member states, but also because of the importance of judicial dialogue. Now this is going to change. It is going to change because it is clear that the dialogue that happens through preliminary rulings is not only of constitutional nature. We have preliminary rulings about everything in EU, even about the tariff classifications of a toilet paper roll or of a pajamas. This is not a constitutional question, but the important thing is that in creating this new reform, the court has been very clear to preserve independent questions that concern constitutional issues and the charter in its hands. So this is the first time in history, I could say, that the court has very explicitly reserved for itself fundamental rights jurisdiction and a constitutional role. With this reflection, we move very quickly to preliminary rulings on fundamental rights, because this example epitomizes the crucial importance of the preliminary rulings procedure for the constitutionalization of the Union and for fundamental rights. The story of how fundamental rights made it to the European legal order is well known. Martin has just mentioned Internationale Handelsgesellschaft, which was one of the first cases, even though not the first one. But we all know the story, right? After a negative answer in Stork, there was a reaction at the national level, and this time it was German courts who posed the questions explicitly to the Court of Justice, first in Stauda and then in Internationale Handelsgesellschaft. We know that from then on, a method developed whereby the Court of Justice was invited on a Praetorian way, on a case-by-case basis, to find general principles of EU law on the basis of the common constitutional traditions of the member states. So here again, national courts were the ones pushing forward the European legal order, and for a long period, this happened through a by-drop case until 2009, where we know that a paradigm shift happened. Even though the court said that nothing changed, everything changed from the point of view of the impact of fundamental rights in the EU legal order. I'm referring to the entry into force of the Charter. So the entry into force of the Charter had as an effect, even though fundamental rights were already a source of EU law through general principles, but the Charter made fundamental rights so visible that they started to feature massively in preliminary rulings. This was a true renaissance of the fundamental rights case law, thanks to national courts, and thanks to the way in which national courts received the Charter and used the Charter. This had an impact also in the Court of Justice itself, because it transformed the docket of the court. It transformed the nature of the cases, and it also pushed the court to transform its own perception. As you remember, in the 90s, we used to say the Court of Justice is not a fundamental rights court, it's not a human rights court. Well, this is no longer the case. So this is very important, because this avalanche of Charter-related cases is related not only to cases that have as its main object the interpretation of the Charter, but in any other case. The Charter features horizontally in any other case connected with any kind of case, any topic of law, even in a peripheral way. This also shapes the legal reasoning of the court and the legal reasoning of national courts when addressing EU law-related issues. So the interaction between the prominent role and visibility of EU fundamental rights through the Charter, plus the complete consolidation of the preliminary rulings in all the member states, where all national courts are super active, has as a consequence that the interpretation and judicial application of fundamental rights today is hugely dynamic. We are living in a constant evolution of the interpretation and development of fundamental rights in the European Union at the national and at the EU levels connected through the preliminary rulings procedure. So both the charter and the preliminary rulings have worked in tandem in this way. And this dynamism is not top-down, it's bottom-up. So the fact that the case on fundamental rights, or the fact that there is a big pronouncement by the Court of Justice on fundamental rights, doesn't mean that it is on the agenda of the Court of Justice, but it is on the agenda most of the times of national courts. And there is an important point to make. The fact that a case on fundamental rights reaches the Court of Justice does not automatically mean a better protection or a higher standard of protection or fundamental rights. The situation is one of dialogue and mutual enrichment, but also one of mutual adjustment. And with this, I come very quickly to the three functions of this tandem of preliminary rulings and fundamental rights. We can simplify and identify three topic situations or functions. The first one will be that through preliminary rulings, this procedure helps us to ensure compatibility of national rules and practices with fundamental rights. The second situation is that also preliminary rulings are instrumental to the legality of EU secondary law. They are a vehicle of constitutionality control also for the EU legal order, as Martin also noticed. And the third element is that the preliminary rulings is a key element to articulate coexistence and the multi-level area of protection of fundamental rights. Also fostering and pushing forward the quality of protection of EU fundamental rights at the EU level. So starting from the element that Martin has already described and analyzed brilliantly, the first type of situation is control of national law, the empowerment of courts in the national legal sphere to protect rights against their own national member state, be that against the legislature, but also the administration, as well as other courts. This is extremely complex because it disrupts everything that we've known before. All the channels, how separation of powers, but also how judicial hierarchies work, are mediated and disrupted by how EU law comes in and is also used through the preliminary rulings procedure. Judges, national judges, very often ask openly about the compatibility of national rules with EU law. As we know, this is theoretically outside the realm of the competences and jurisdiction of the EU court. And what the EU court does is to reformulate the question. Now it is not so much necessary to do that anymore because it is clear that the preliminary rulings procedure serves as a quite direct, indirect mechanism of control of legality at the national level. But it also means that the Court of Justice cannot invalidate national law. This is a task left for national courts. As we were commenting already in the first presentation, this is extremely complicated to do for national jurisdictions because they have to dissociate their brains essentially in a bipolar function as judiciary of the state as well as the judiciary of the European Union, and work against all the instincts that were placed in their legal education ever since they were in law school. For example, empowering them to disapply a law adopted by the legislature. So this has a big impact on how some judges perceive the principle of legality. The principle of legality is now an EU law broad principle and the framework towards which national judges have to measure their action escalates to the supranational level. But also it asks, the EU legal order asks national judges to deviate from the case law of higher jurisdictions, even from the Constitutional Court, And it also forces them to modulate its legal order in ways that is not foreseen. Martin just mentioned the Torubarov case, which is a case that we had in the cabinet of Advocate General Bobek when I was working with him. This was an extremely difficult case at all levels. And the far-reaching pronouncements of the court, of course, are extremely difficult to touch ground in the legal reality of the day-to-day judges. So moving beyond this clear function of the preliminary ruling procedure as a way to control the legality, there is an additional layer to it in these last times that we are living through the rule of law backsliding, to which Professor Hallmeier referred in his presentation this morning. What we are now living here is not just mere questions of legality, but we are even questioning structural principles and the democratic principle and how all this unfolds within the very identity, the constitutional identity of the European Union itself. So it is national courts mostly who are also pushing new topics in the EU law sphere, so that these crucial elements are only placed in the agenda thanks to national judges. So all this comes with a lot of problems, practical problems. And of course, from the point of view of a national judge, we cannot ask national judges to be heroes all the time, to rebel against the hierarchy, to rebel against a constitutional court, to rebel against government. Some of them are prepared to do so, but this is something that we are very sensitive about at the EU law level. Of course, from the legal point of view, and I invite everybody to read the RS Romanian ruling of 22nd February 2022. The RS case is like a handbook ruling, not only explaining what the principle of primacy means for the day-to-day powers of national judges, but also about the protections that this procedure has with it. For example, that national judges cannot be subjected to disciplinary procedures for fulfilling these duties. And also this case has a preliminary ruling case has a very important element for the development, the future development of preliminary rulings in this important area of how the rule of law unfolds and how national judges can rule of law problems. The court has made very clear that national identity of a member state cannot be used as a shield to protect against non-compliance with EU law, and it is the Court of Justice itself who has to be seized on this matter of the possibility to use Article 4.2 of the Treaty of the European Union. We should not forget that the rule of law, case law, in which now the Commission features as one important actor through infringement procedures, was made only possible through the preliminary ruling procedure initiated by the Portugal Court of Auditors in the famous Portuguese judges case. So in this way, we see how this interesting way of moving forward through the preliminary ruling procedure has helped to create a new avenue for the protection of the independence of national courts themselves. I'm not going to delve a lot on the second function that I portrayed, which is the control of EU law, but it is extremely important to remind you that one of the most central pieces of the system of constitutionality and legality control of EU law itself is the preliminary ruling procedure, through the preliminary rulings of validity. This is for two reasons. First, because the direct control of legality is extremely narrow. It is almost impossible for private parties to go to the Court of Justice and ask the Court of Justice to check directly the validity or constitutionality of EU legal acts. And second, because the deadline is very short for direct actions of annulment, it's only 2 months. So after these 2 months have elapsed, after a legal act has entered into force, has been adopted, we have no other way of checking it but through indirect means. And one of these is the validity preliminary rulings. In the last, okay, sorry, could I ask you to mute your microphone in the room, because it's very loud, the sound of the room.
Done.
Thank you so much. Okay, thank you so much. So this shows how the preliminary ruling is a key element in this complete system of remedies, and how once we have closed the path of annulment, it is only through national judges that we are allowed to test legality of EU law through national courts. We very much know the very important rulings of Digital Rights Ireland, Sa, and most recently Landeshauptstadt Wiesbaden, checking fingerprints in ID cards, or Ordre Flamsebalis, cases in which it is the national judges who bring the issue of validities with the threshold of fundamental rights to the Court of Justice. But to finish with, probably the most important function of the preliminary ruling procedure from the systematic point of view is that of shaping the EU legal order. The preliminary rulings procedure is crucial to co-creating this multi-level system of protection of fundamental rights. First, as Martin already said, it has been key for the progressive determination of the scope of application of fundamental rights. And this is the key federal question. Second, it is crucial to articulate the coexistence of different protection standards depending on the intensity of EU competences in different fields. And third, it is the main avenue for the evolution of the EU legal standard of protection itself through judicial dialogue. And this has been the case ever since Stauder and Internationale Handelsgesellschaft. Regarding the determination of the scope of fundamental rights, you know how difficult this issue is, and how it has been national courts who have pushed forward with ever more difficult questions about the scope of application. The scope of application of the Charter has been exclusively determined through the preliminary rulings procedure. We know the Ackerberg-Frankson-Meloni tandem, the long line of orders and preliminary rulings on Article 50, or more recently, the important case Protectus. This has been all pushed through by national courts. And the message here is that the court has not have a clear predetermined picture. This scope is evolving with the next preliminary ruling question, because the reality that is being put forward by national courts is always more complex and reaches beyond the structures of already settled case law. The second element is the creation of an articulated system of coexistence of different protection standards. Here, you have the very famous tandem of cases, Tarico, MAS, and later on the Romanian case, Lin, whereby we have an interpretation of the Court of Justice of the principle of legality that runs counter the constitutional conception of that same principle in Italy. And we have something that is extremely important, a follow-up question. Instead of creating a constitutional rupture and saying this was ultra-virus or we are not going to follow the Court of Justice, the Constitutional Court of Italy came back to the Court of Justice to explain, to ask for an evolution of the case law, and this pushed the European legal order further to be a little bit more flexible and to also create a more sustainable standard of its own interpretation of the legality principle internally. This dialogue and this back and forth of preliminary rulings is extremely important, as opposed to situations where a constitutional court simply decides to break the bridges, to burn the bridges, and to cut off dialogue and just to disobey. Or not disobey. It depends from the point of view of from which we are talking. Also, this, as I say, it is extremely important as an element of vehicle for evolution of adjustment of the EU law legal system itself, which is a novel legal system with problems which are new all the time. One of the main problems, for example, in the fundamental rights sphere are the problems posed by the mutual recognition system and fundamental rights. And when can we derogate from this mutual recognition and mutual trust on the basis of fundamental rights? Here we have the famous cases MS in the asylum field, but then the follow-up of Arangiosi and Caldararu and all the follow-up cases in which national courts do not shy away from coming back to the court and asking for specifications on the practical implications of its theoretical rulings. This is something that Martin also reflected upon. The replies that we get from the level of preliminary rulings that we get from Luxembourg sometimes stop at the theoretical level and do not speak about the practical implications, because sometimes the question was framed in a material way and not in a procedural way. And sometimes the court is not aware of the practical difficulties. Again, the insistence of national courts on coming back, pointing at the precise practical problem is completely key to the functioning of the system. But it is also a key element of the system, the autonomy of courts to take these solutions and be creative in the own legal systems within their own national boundaries. So from this point of view, the role of national courts as a vehicle of transformation is the idea that I will want to leave you with. It is thanks to national courts that EU law has bridged the barriers for judicial, for effective judicial protection. For example, we've seen in the area of the common foreign and security policy and the Rosneft case, where national courts put and push national or effective judicial protection further, but also when national courts in general place at the heart of their questions fundamental rights, they are also progressively changing the EU legal order and the role of the Court of Justice itself, because they perceive the court as the correct interlocutor in these constitutional matters, and the court needs to be fed by national courts. As I tell my students, EU law and EU constitutional law is a little bit like the artificial intelligence. We need to be fed, or EU law needs to be fed from the national legal systems all the time. There is hardly an original idea there. It is national judges and before them national lawyers who are putting out there the brilliant solutions and the innovative questions. The role of comparative law through the veins of national courts must not be never forgotten, because comparative law is there at all stages, not only in the preliminary ruling that you are sending as a national judge, but also all throughout the preliminary ruling procedure in which all the member states are allowed to participate, sending in their feedback from the national legal system. And in very important cases, also the research department of the Court of Justice asks for comparative law notes where most of the EU legal systems are represented. So national courts shouldn't shy away from explaining to the court the particularities of their problems and posing new issues that push further EU law. This is the cause behind the constitutionalization of EU law, the push bottom up from national courts, putting in the agenda rule of law issues, fundamental rights issues. And now we have, I cannot avoid it, I'm coming from Spain, we have new topics making it through, which are completely new. For example, the amnesty law in Spain, a matter of which our constitutional law is seized, has made it simultaneously to Luxembourg through 3 preliminary rulings, where we are going to be faced with some new topics in which the court has never had a say before. So the fact that also constitutional actors such as courts try to move to Luxembourg as the legitimate interlocutor in constitutional issues is extremely significant of the importance of national courts in this evolution. So just to conclude, preliminary rulings are the blood of the system through which national courts become the co-creators of EU law, and it's an extremely powerful tool which has transformative power. I just want to underline that, well, national courts are the ordinary judges of EU law, but not only that, they are the judicial power of the European Union in all senses, as Article 19 explains. And from this point of view, we have to look at the case law of Luxembourg not as something that comes from the fairyland of Luxembourg in Kirchberg, in the palace, in the Golden Towers, but something that we create ourselves together through the quality of our preliminary rulings, the insistence of getting back to the court for clarifications, and the braveness to bring up questions that have probably never been posed before. I thank you so much for your attention and your patience, and I remain, of course, at your disposal for further discussion. Thank you so much.